Yes, good evening to the aspirants of the PG LACET 2023, and please read what I posted on the screen so that I am with you and you are with me. Both are sailing in the same boat to reach to the destination. Read. Anyone can unmute and read. I said anyone can unmute and read what I posted on the screen.
Yes, sir. This homepage MCQs in Mercantile law.
At least I could hear that you saw that what is posted on the screen. Yes, in my yesterday class, I dealt up to this extent where I put the strict marks, but I did not deal the options. 24th question. Under section 36 of the Specific Relief Act 1963, an injunction is defined as an order of a competent court which a. Forbids the commission of a threatened wrong. B. Forbids the discontinuation of a wrong already begun. And C. Commands a restoration of the status quo within parentheses the former course of the thing. And D. All of the above. Again, I will show you the question. Better I can drag it to the next page so that you could see the total things. I repeat the question. Under section 36 of the Specific Relief Act 1963, an injunction is defined as an order for the competent court which A. Forbids the commission of a threatened wrong. B. Forbids the discontinuation of a wrong already began. C. Commands the restoration of the status quo within parentheses the former course of things. D. All of the above. Shoot the right answer among the ABCD. Yes. See, in this one, a little difficulty would be there. See, forbids the commission of a threatened wrong, it's very much useful. Forbids the discontinuation of the wrong already began or there. Commands the restoration of the status quo and there commits a mistake. There I made it forbids the continuation of the wrong already began, which is not relevant. Here, forbid the discontinuation of wrong already began. I should have to ask the question, which is not relevant. Which is not relevant. Others are relevant. Is it clear?
Yes, sir.
Did you follow the question? Which is odd one out means not relevant. So A is relevant, C is relevant. Of course, C, B is not relevant, so there is no question of all the above. Is it clear?
Yes, sir.
Now, 25th question. Anyone can unmute and read the 25th question?
In dash AR 1949, PC 90, it was held that if shares are freely available in the market, then specific performance would not be granted. If shares of a particular company, for instance, a private company, are not readily available in the market, specific performance would be granted. Option A, Bank of India versus Chinoy. Option B, State Bank of India versus Chantal. Option C, Union Bank of India versus Shenoy. Option D, Bank of Baroda versus Shri.
In which case law the above statement was decided among the ABCD? There is no negative mark. Shoot. Hunch. Anticipate.
Bank of India versus Chennai.
Repeat.
Option A.
You are right. Option A is the right answer. Bank of India versus Chinoy, Chinoy, is the right answer. Sometimes, even though you don't know which is the answer, but your sixth sense says, because you can apply the various other equations and come to the right shooting, that what you did the same today now. Now next comes to the right answer for the 25th question is A. Bank of India versus CHINOY, Chinoy. Now, 26th question. The Indian Partnership Act 1932 defines a partnership as a relation between the two or more dash who agree to share the profits of a business run by them all or by one or more persons acting for them all. Option A, people. Option B, individuals. Option C, publics. Option D, persons.
Sir, D, persons.
Persons is the right answer. Not the people, not the individual, not the public. Because when you read it, your common sense says persons is the right word. Is it clear?
Yes, sir.
Yes,
Now, 27th question. Subject to contract between the partners, the property of the firm includes all property and rights and interest in property originally brought into the stack of the firm are acquired by purchase or otherwise by or for the firm or for the purpose and in the course of the business of the firm and includes also the dash of the business. A, benefit. I will pull down to the next page. Drag it to the A, benefit. B, profit. C, goodwill. D, interest. Which is the appropriate word for the dash?
Sir, C, goodwill.
Goodwill is the right word. Here, even goodwill we can sell. We can demand. So the appropriate word is not the benefit, not the profit. It is the goodwill is the right word in that particular place. Now you 28 read and give the right answer.
A partnership agreement is an agreement between two or more individuals who sign a contract to start a dash business together. Answers: A, profitable. B, lucrative. C, gainful. D, money making. Sir, A, profitable.
Profitable is the right word. Not lucrative, not gainful, not money making. Profitable is the appropriate word. So now 29th question. What are the different type of partnership? A, general partnership. 2, special partnership. 3, limited partnership. 4, limited liability partnership. Options goes in this manner. A, 1 plus 2 plus 3. B, 1 plus 3 plus 4. C, 2 plus 3 plus 4. D, 1 plus 2 plus 3 plus 4. Which option is the right option?
Sir, B, 1 plus 3 plus 4.
You are right. B is 1 plus 3 plus 4 because there is a general partnership is there is a limited partnership is there, limited liability partnership there. I concocted a special partnership. Hence, you eliminate the two, then the right answer for the 29th question is B, 1 plus 3 plus 4. Now, 30th question. According to Dash, the minimum number of members required to form a partnership business is 2, while the maximum number of membership can be 100 and not more than that. Which act says? A, Indian Partnership Act. B, Society Registration Act. C, Cooperative Society Act. D, Companies Act.
option D, Companies Act.
You are right. Exactly the you stated correct. According to the Company Act, the partnership can be made. So that is the right answer. That is the right answer for the 30th question is D, Companies Act. Now, 31st question. Anyone can unmute and read?
Some of the essential characteristics provide a distinctive identity. These are: 1, movable, 2 written, 3 definite time, 4 persons. Answer A 1 plus 2 plus 3, B 2 plus 3 plus 4, C 1 plus 3 plus 4, D 1 plus 2 plus 3 plus 4. The question, please, sir.
Yes, which option is the right option?
Sir, can you scroll, please, up, sir?
Yes, now I will. Okay, I will drag down to the next page so that you could see the total. Yes, now I dragged it. Now you can see now. Some of the essential characteristics provide a distinctive identity. These are movable, written, definite time, persons. Options.
Sir, 2 plus 3 plus 4, B.
WRONG.
Mahendra,
No.
you guess.
You are right. Actually, I made movable is there. Movable
Yes,
is there. Written is there. Definite time is there. What I did it, specified person, I removed the specified, I said the persons. So, what is the right answer?
So 1 plus 2
1
plus
plus
3.
1 plus 2 plus 3 is the right answer.
Sir, actually, can I know the meaning of the question, sir? Exact
Yeah,
meaning.
the meaning, see, we are discussing the now partnership.
Yes, sir.
So, the essential characteristic of the partnership identity is,
Okay.
that is there will be a specified persons and other things as usual follows.
Okay.
Now let us go to the next negotiable instruments. Let us have a look at the purpose of the Negotiable Instrument Act, which is the odd man out, means not relevant to the Negotiable Instrument Act. A. The Act defines every subject related to the negotiable instruments for better clarity and understanding. For example, who is the drawer, drawee, acceptor, etc. are mentioned in the various sections. B. The Act provides the duties of the parties when they discharge their obligation diligently. C. The Act mentioned the different conditions about the transaction systems and laid down its specific provisions. D. The Act regulates the different negotiable instruments like promissory notes, bill of exchange, and checks. One is not relevant to the negotiable instrument, but other three are very much relevant to the negotiable instrument. Which is the one not relevant among the ABCD?
Sir, C.
Means the Act mentioned different conditions about the transaction system and laid down its specific provisions.
Sir.
No. Wrong answer.
Option B, sir. The Act protects duties of the parties when they discharge their obligation.
Repeat.
Option B.
You are right. Because the Act provides not the duties of the parties, the rights of the parties. I changed rights to the duties. The Act provides the rights of the party when they discharge their obligation diligently. That means B is not relevant. Is it clear?
Clear, sir.
So
Yes,
that is the psychology, that is the methods, that is the shooting. You should use the x-axis, y-axis, z-axis and shoot in 3 dimensions. And I'm sure even though you don't know the answer, you can shoot properly. Now 33 question. Of course, unless until you read some cases, then only you could understand. But you can shoot it also depending upon the ABCD. Now let us check it. The judgment of the Apex Court gives the better clarity. Section 147, the Honorable Supreme Court in the case of Dash 210 stated that Section 147 does not carry any guidance to how to proceed with the compounding offences and further notice that Section 320 of the CRPC also cannot be applied. Therefore, the Apex Court exercised the power under the Article 142 of the Constitution and laid down guidelines for the encouraging the compounding at that stage. This is about the NI Act only. A. Vishwas Kumar Babu Bhai Chaudhary versus State of Gujarat. B. Amandeep Singh versus State. C. Damodar S. Prabhu versus Syed Baba Lal H. D. Gurpal Singh versus State of Punjab and others. In which case law the above statement was decided among the A, B, C, D.
Sir, A.
WRONG.
I think option D. Gurupal Singh was state of Punjab and others.
WRONG.
Sir, C.
C is the right answer. Damodar S. Prabhu versus Syed Baba Lal H. In that above statement is made. Of course, such things, no, we cannot read all the cases, but we can apply our logic. It doesn't matter. See, what we are going to get here is how many marks. See, the point is out of 100, if you score 60, you will get a good college.
Yes, sir.
Not necessarily you should score 70. Because even myself also cannot score 80. No. But
Oh,
I can shoot it. In the shooting, I can get at least out of 20, I can make it 12 right in the shooting. Only guess.
50%. Yes.
Yes, now the 24th question. The NI Act is a dash in economic and finance related matters. A. Keystone. B. Foundation. C. Cornerstone. D. Basis.
Sir, D. Basis.
WRONG.
B. Foundation.
Cornerstone is the right word. The NI Act is a cornerstone for the right act. Just a minute, somebody is coming. Yes, I'm here. Yes, verifying. No, whether my student, my board about man has come. You okay? When not coming, no, I will call you later because I am in the online class. Yes. Now, 35th question. The relevance of this section related to the issue pertaining to the NI Act can better be understood from the case of Dash. It's a 2020 case law. The Delhi court dismissed the petition filed against the order of the session court. It was a review petition that was filed by the petitioner for the turning down the order of the Metropolitan Magistrate relating to the matters innovated under Section 138 and Section 149 of the Negotiable Instruments Act 1881 that was against the petitioner. And which case law? It's merely you can guess and shoot it. A. Krishnan versus Krishnaveni. B. Tata Export Private Limited versus PEC Limited. C. Suman Sethi versus Ajay K. Churiwal and others. And D. Rajati versus C. Ganeshan.
Sir, B. Tathagat Export.
Option
You are suited exactly. I don't know what method that you used. I don't know what method you use, it doesn't matter. But your shooting is exactly. I told you, if you make a mental setup by using the different software in it, even though you don't know the answer, you can shoot it perfectly. Because you already made the software in your brain in the different angle. Okay, 36th question. In clause 1 of the section 2, the term buyer is defined to include both a person who actually purchases the goods and a person who is almost willing to do so. However, it was observed in the Dash 1895 that a person is not regarded as a buyer if an agreement essentially grants him the option to purchase the products without subjecting to any legal obligation to do so. Now I said seller and buyer. So it comes under the
Seller and buyer.
Sale of Goods
Contract,
Act.
Sale of Goods Act. Okay.
Yes. And A, Shogun Finance Limited versus Hudson. B, Kandi versus Lindsay. C, Halby versus Matthew. D, Richmond Adult Community College versus McDougall's. See, this is the classical case law in the Sales of Goods Act. And there, a person is not regarded as a buyer if an agreement essentially grants him the option to purchase. I say option to purchase the products without subjecting him to any legal obligation to do so. So, which is the case law where it is decided among the ABCD. Now, use your permutation or combination and shoot.
Option C.
You are right. Halby versus Matthews is the right case law. I don't know what permutation combination that you use in it, but your shooting is very much perfect. 37th question. Dash, on land which was agreed to be served from the land before the sale was held to be the goods in the case of state of Maharashtra versus Champalal 1971. Number A, the standing grass. Number B, the standing crops. Number C, immobile property. And D, the standing timber.
The standing timber.
The standing timber is, you made the hat trick today. You're clapping.
That's for Mahinder.
Hey, yeah. Because I saw here the name is Mahinder.
Yes, sir. it's
Because
Mahinder.
Kishore used to hear my lecture. Mahinder, I don't know how many classes that you heard.
Last yesterday and the day before yesterday, I didn't attend. So previous day I was attended.
Okay. Now, 38th question. The basic requirement for the contract of sale are as follows. Number 1, it may be in printing. Number 2, it may be by word of mouth. Number 3, it may be partly oral or written. Number 4, it may be implied from the conduct of the parties or by the course of their business. Now option goes in this manner. A, 1 plus 2 plus 3. B, 2 plus 3 plus 4. C, 1 plus 2 plus 4. D, 1 plus 2 plus 3 plus 4.
D, 1 plus 2 plus 3 plus 4.
WRONG.
Option A, 1 plus 2 plus 3.
Option A is right. Why? The reasoning is, it changed, it may be in writing. I changed it into it may be in printing. Is it clear?
Yes, sir.
So you read the terminology, what it is given, then you can shoot it. So it may be in writing, not printing. Printing is an option. Of course, now everybody uses the printing. Am I right?
Yes, sir.
Your 39th question. Anyone can unmute and read the 39th question?
As per section 6
Yeah, Mahinder, go on.
of the following types of existing or future further goods from a part of the subject matter of the contract. The option 1, the goods may be existing or whose possession will happen in further.
In the
The
future.
goods whose hello, sorry.
Yeah, okay, let me read it. Number 1, the goods may be existing or whose possession will happen in the future. Number 2, the goods whose acquisition is dependent on a contingency. Number 3, where there is a present sale of future goods. And these are as per the section of the following type of existing or future goods from the part of the subject matter of the contract under the Sale of Goods Act. Option A, 1 plus 2. Option B, 2 plus 3. Option C, 1 plus 4. Option D, 1 plus 2 plus 3. Let me drag to the last page so that you could see total at a time. Yes. Now you can see everything.
There is no fourth option here, sir, actually.
Yes, no, there is only 1, 2, 3.
Yes, okay.
Now you choose among the ABCD.
So 1
Option
plus
D.
2 plus 3.
Yes. It is 1 plus 2 plus 3 is the right answer. Because I did not change anything here. Yes, you are right. Because I thought of changing, but I could not get the scope of changing it. Because I cannot say in the past. I can say the part will happen in the past. But I said, no, let me make confusion like this. Let me see whether they are shoot in a proper way or not. So the right answer for the 39th question is 1 plus 2 plus 3 is the right answer because all are very much relevant to the section 6. Now 48th question. Res perit domino, a Latin maxim, means the object is lost to the owner of the property. This theory is applicable when selling movable property according to dash of the Sale of Goods Act of 1930. A. Section 26, B. Section 27, C. Section 28, D. Section 29.
Mahinder, shoot.
Option B.
WRNG.
Sir, 29.
WRONG.
26.
You are right. 26 is the right. See, sometimes no, even I could ask the Latin maxim, but people know the Latin maxim. Better you put different way. So I did not ask the question Latin maxim. I asked the section. I would like to see how they can shoot the section. But the maxim, they can shoot it because they can use their own permutation computer. Res perito domino. Domino means domain, means owner. Res, they will make it out. At least something they will come out when I make the options. But anyway, that is the right answer for it is here. Section 26 is the right answer. And today I made this much by taking, to be frank, can you tell me what are the things come under the mercantile law? Keep your hand on your heart and tell me.
So it's completely.
Of course, Kishore, I already told you. Kishore, your name not to say.
Yes, sir.
Myself, Mahinder, sir.
Yes.
It is a international commerce, business, trade, business transactions.
I appreciate. See, to me also, I'm teaching this course, but even myself also got shocked when I really searched it. Do you know how many acts will come under it? The acts also listed below: the Tariffs Act, the Indian Contract Act, the Negotiable Instrument Act, the Presidency Town Insolvency Act, the Provincial Insolvency Act, Sale of Goods Act, Indian Partnership Act, the Insurance Act also. Of course, I eliminated, but generally the insurance they cannot ask, but there is a possibility they can ask Insurance Act, Indian Partnership Act, Sale of Goods Act, a Negotiable Instrument Act, Indian Contract Act, the Tariffs Act. I covered all the green which are there, but only the insurance I left it. Okay, you may ask, they may ask 1 or 2 questions, but I trained you in such a way you can shoot it even though you don't know the answer.
Yes, sir.
Because that is very important factor. We are not supposed to ask the question easy. No, you ask the question critical way so that you could have the 3-dimensional object and when you can shoot from any angle. And these are the question of my brainchild. I created it. I made it. And if you happen to see my last year's mercantile law, and I'm sure that you could not find the coincidence. If at all find the coincidence, but the mode of asking may be the different. Am I right? Because it is me who created it, hence I know it in what way I created it. If I create,
Last year also,
yes, please.
sir, last year also you conducted classes, sir, for
I conducted at least 4 times.
Oh.
You can get PGLCET. You just type my name in the Google search engine. For instance, I will show you the way you can make it out here. Yeah, where I kept it. See, I put it the file here one. Yeah, it is here.
Sir, actually, sir, for this LLM entrance, sir, the issue
Yes.
is the scope of the subject is very huge, sir, actually. Enormous.
See, I told you no, they can
Yes.
ask in any manner. But when you
Yes.
know the technique of shooting, it's enough.
Ah, correct, correct, sir.
Only they can ask any manner. But if you know the technique of shooting, and I'm sure because you can shoot when the four options are there.
Yes.
But
He
I give
told, sir,
them
actually,
that
in
you
fact.
cannot shoot it. See, you type in the Google search engine, my name,
Yes,
Mohammed
sir.
Saheb Hussain,
Yes, sir.
and you
Yes,
will
sir.
get my blog here. And these are all the things. And here the convex lens is here. You type PG loss, PGL set. Enough. Don't type here.
Okay.
PGL set here. It's enough. See, you can find the here. Did you find it? PGL set 2020.
Oh, right. 2020.
PGLCET 2023.
Okay, okay.
PGLCET 2020. And 2020. 2020. And this is PG set 2020. No, 21 also I dealt it. But I dealt 2 times, 3 times I dealt it. PGL
Okay.
set 2020 and 21 also there. Some of them. Yeah, 2020 and that online class start and crimes. And if you happen to see today mercantile law, see this is the mercantile law. I will just show you an example. I will show you an example
Yes, sir.
because when I share it now, you could not hear it unless I could manage something here. Yes, I managed it. Yes, now you could hear it just for a moment. We could know that you
Yes.
could have no certain techniques to shoot the answer. So that's why, even though it's wrong, doesn't matter. There is no native marks. Hurry up.
Express contract is made by words
Answer is
spoken.
B. Words spoken. Express contract is made by words spoken.
Yes,
That's the
correct.
third question. Indemnity means A. Security from damage or loss. B. Security for mere protection. C. An act for protection. D. Both A and B. Are you hearing?
Yes, sir. Yes, sir.
Yes, sir, we are hearing.
Indemnity means. Now it should. Loss. B. Security for more protection.
Option D.
C. An act for protection. D. Both A and B.
Both A and B, sir.
Yes, that is the correct answer. D. Both A and B. It is security from damage or loss and security for money protection. Next. Question number 34. Section 2E. The Indian Contract Act 1872 defines A. Offer. B. Contract. C. Agreement. D. Acceptance.
Acceptance, sir. Option D.
It is C. Agreement. It is E. 2E. That is agreement.
What is acceptance? Okay, okay, sir. Got it.
2E agreement. Definition of agreement is section 2E. 35th question. According to Dash, every agreement and promise enforceable at law is a contract. Who said A. Benjamin, B. Austin, C. Holland, D. Pollock. According to Dash, I quote, every agreement and promise enforceable at law is a contract. I unquote. A. Benjamin, B. Austin, C. Holland, D. Pollard.
Sir, option C, Holland.
It is option D. Pollock.
Okay.
Pollock defined it as every agreement and promise enforceable at law.
36th question. An agreement participated by a minor must be considered as null and void in the eyes of law. It was decided in the case of A. T. Raghavacharya versus O.S. Srinivasa Raghavacharya. B. Nazir Ahmed versus Jeevan Das. C. Mohili Bibi versus Dharmadas Ghosh.
Moirin Bibi versus
Indra
Damodar Das Ghosh.
versus
Option C.
Chettiar.
Yes, you are right, Mahendra.
Option C, sir, Mohini Bibi.
Yes.
Yes, that is the correct answer. Option C is the correct answer. Mohili Bibi versus Dharmadas Ghosh.
Did you see any coincidence of any questions?
Judgment.
Answer is no.
37th question. Which section of the Indian Contract Act says, I quote, when an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it. When an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it.
Option D, sir, D 60.
Option D. Sir, check the answer.
65.
Yes, option 65. B, section 65 is the correct answer. 38%.
Yes, B, section 65 is the correct answer.
Guarantee, I guess.
Should have that. You can make it a clear cut now. What are the sections? Section 6. So, this is the way that I conducted in the last year. Did you see any coincidence here? It's a question coincidence. Answer is no. 65 is Indian
Not guarantee here.
Yeah, you are showing 65. Whether 65 or not, you are showing. 65 the Indian Contract Act 1872 says, where an agreement is discovered to be void or when contract becomes void, any person who has received any advantage under such an agreement or contract is bound to restore or to make a compensation for it to the person from whom he received it. So whether we wrote the same thing? Yes, we wrote
Yes,
to make the confirmation. Is the right answer. Section 66 is the right answer for the 37th question.
65 is the correct answer.
Yes.
38th question. A person who has crossed 17 years and 364 days old will be viewed as a dash in the eyes of law. A. Child. B. Boy. C. Major. D. Minor.
Minor D.
Major.
Yes.
Minor 18 plus major.
Supplementary question.
Mhm.
Supplementary question is
D minor.
the majority will be measured. Which act says regarding the majority?
I don't remember.
The majority act. There is act is there.
The majority act.
Mistaken section.
1956 or 1965 something is there.
Major.
Indian Majority Act.
Next.
Indian Majority Act 1956 or 1986 or something.
We were discussing about the act number of 1856.
Yeah, but when you read the section 10 of the Indian Contract Act or section 11, they say who is competent to contract, then they referred for the majority, refer the Majority Act.
No, sir. Yesterday we had a doubt
Yes.
regarding the act number of 1856. I found it. That is act number 1.
That's Act number 1. Okay.
1856.
You want to say that?
Companies Act.
Yes, Companies Act. Yeah, now we are discussing the contract here. Okay. Okay, clarity is there. Act number
39%.
Yes,
Act
39%.
number 1. The Indian Mercantile Law is based upon
भारत भाग्य विधाता
पंजाब सिंध गुजरात मराठा
द्राविड उत्कल बंगा
विंध्य हिमाचल यमुना गंगा
उच्छल जलधि तरंग
तव शुभ नाम जागे तब शुभ आशीष मांगे गाहे तव जय गाथा
जन गण मंगल नायक जय हे
भारत भाग्य विधाता जय हे जय हे जय हे जय जय जय
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
ख्वाब तो सिर्फ कश्मीर की आज़ादी के आते हैं।